Next up, we have Alessandro Di Mattia. He is a very, very passionate individual about privacy and data security and supports the coordination of international operations within Privacy Rules. Privacy Rules is a global alliance covering 60 countries with legal, cybersecurity, and cyber crisis communication. He will speak to us as a hero because he has helped countless organizations around the globe protect their data and their users' privacy, obviously. Sorry. In his talk, Beyond GDPR, Navigating the Global Privacy Landscape, he will talk about new privacy regulations which are coming into effect all over the globe. He will tell us how to navigate this new landscape, how different behaviors and compliance levels from country to country can come into place in your organizations. He will also go more into detail about China's and India's new data protection bills, which differ substantially from the European regulations, and give us insights on approaching and dealing with these new legislations in major global markets. Give it up for Alessandro Di Mattia.
Hi, everyone. It's a pleasure to hear. Can you hear me? Yes. OK, perfect. It's a pleasure to be here. First of all, I would like to thank the JENTIS organizers for this wonderful event. I really think that is a great occasion to have discussion with many people that are interested and passionate on privacy, as I am. The topic of today, as you can see, is going beyond GDPR. How will we do this? My approach would be to, first of all, give you an overview on some of the main issues that normally GDPR-compliant companies face when they deal with other frameworks. Also, we will go deeper into two cases that are the Chinese PIPL and the Indian Privacy Data Protection Bill. This latter is just a draft, so it's not yet implemented, so keep this in mind. But those are very interesting for a variety of reasons that we will see together. Before doing that, I'd like to give you a little overview, if this works. Yeah. On who we are. As mentioned during the introduction, Privacy Rules is a global alliance. We have the unique element of being a group combining tech, legal, and crisis communication experts. Why we did that? Because we really think this is the best way to provide better services to companies all over the world in order to comply with data protection regulations, because they all require this type of expertise. We, as said, cover 60 countries all over the world, and we work with specialized firms on a country-by-country basis. So we have legal experts for each of those countries. Under the cybersecurity side, we work with offices, regional offices, in order to cover, again, the world. Under the crisis communication, we're able to provide services in many different languages, the most spoken one, English, French, Spanish, Portuguese, and Chinese as well. But let's go deeper on our presentation of today. Now, in this first slide, you can see how we have divided various situations in which you may find yourself. That are the one of dealing with EU-adequate countries, meaning countries that have been recognized as providing the same level of protection to personal data of the GDPR. We have GDPR-oriented laws, meaning laws that have been created, in most of the cases, after the GDPR implementation, that are laws that are very, or more or less heavily based on GDPR. And the third one is the case of non-GDPR-oriented law or no privacy law at all. So based on these three cases, we made to our members, some of them selected, a very simple question. That was, which are the main problem, the main issues faced by GDPR companies, compliant companies, when dealing with your specific framework? And we received many different answers. We have been receiving many different issues, but the key ones we found are listed there, and are the ones that were repeated more and more often in all the various countries that have been answering to our question. And the first one is the legitimate interest. As you probably know, legitimate interest is one of the most used legal bases under the GDPR. And the problem here is that it's not recognized in many countries abroad. So you need to know that in order to process data and to use data in other countries, you have to find alternatives to legitimate interest. And the interesting thing is this legitimate interest as data portability, that is the next one, were also issues that were raised by adequate countries. So there are many countries also under the adequate ones that are heavily consent-based countries. The only different one that is not based, really consent-based country is the US, under the federal perspective at least, because then we know that there are more specific state laws. But the US has a different approach that is not based on consent, is based on the so-called opt-out system, meaning that generally the companies can start using and processing data, but have to give to the individual the opportunity to say, I don't want you to keep processing my information, my data. This is the opt-out. Second problem or element we found was the one of data portability. Data portability is normally the right to require companies to transfer your data from one to the other, or to ask to receive your data or the data you have given consent them to use in a readable format, simple format. For what concerns data portability, we see that this is one of the data subject right that is almost never recognized in the other countries. So this is something you need to know as well. Similarly, data erasure. This is normally recognized, but in a different manner from the one we have to in GDPR. So you have to check, for example, which are the conditions through which data subject can ask you or your company to erase their data, and how you have to do that as well. Another point is the registration requirement. In many countries, data controllers are required to register into specific database in order to be identified as company dealing with personal data within that country. And this is quite complex one because normally is not known. Sometimes it's based on different sectors, so it depends on which kind of data you use. And these also in this case, depending on how is the approach of the authority, and the sanction that you can receive for not complying with it can be pretty heavy. So that's another thing to keep in mind. Last but not least, 2 points are the criminal liability and the data protection officer requirement. For the data protection officer requirement, we saw again that there are many countries that don't require it. For example, Japan is a country that is an EU adequate one. You may want to have a data protection officer there, but it's not mandatory. Differently for the criminal liability, that's one of the issues that normally companies want to know about. There are countries that oversee for individual or criminal liability, in particular for the person that is appointed as manager of the data protection for specific companies. And this is something we will see, for example, also in China under the PIPL, that is the Personal Information Protection Law in China. That said, I would like to move on with our two specific country laws that are the PIPL and the Indian Privacy Data Protection Bill. Why did we select them? First of all, because by addressing them, we will see some of the main issues that are normally faced by European companies with dealing in general with other companies all over the world. Second, those are both extraterritorial, so considering that those are big economies, it's very easy to fall within or under the scope of those laws. The third and fourth point are related more to the specific law. The PIPL is more and more recognized as an additional global standard to GDPR. To give you an example, in Asia, we are already having some countries that are looking at the PIPL as much as GDPR in order to make sure that their data transfer compliance with the Chinese law is okay, so that they can transfer this data. Hong Kong is one of the most recent examples. They have recently proposed and they are implementing new law, in particular in relation to data breach notification requirements. And what they've been doing is that the proposal was made back in 2020. Now they are proposing this again in 2023 after checking that this proposal was aligned with the Chinese law as well. For what concerns the Privacy and Data Protection Bill of India, that's interesting because this is one of the few cases after the GDPR implementation where we see a law that is shifting from the GDPR. So it's interesting to see how and why. From now on, what I would like you to keep in mind is that all the type of issues that we are going to face are related, of course, to the laws I'm mentioning, but are issues that you normally will face also by handling or having to deal with different countries in general. One of the first one is always the issue of definition and terminology. In many cases, there are frameworks, country frameworks that use similar terminology to the one of the GDPR, but with a different meaning, or totally different terminology. To give you some example, under the Chinese law, and comparing it with GDPR, we have sensitive personal data that can be basically compared to our special categories of personal data. In both cases, we are providing, GDPR and PIPL provide an additional level of protection to them, but the categories listed under them are not the same. So you need to know when there is this level of protection respected in the Chinese law and when it's not. Differently, under the Indian law, we do not have this type of distinction. So when you deal with them, you need to know that they do not protect sensitive personal data as GDPR requires. Another difference is the one between the term of data controller and its meaning, and that's quite confusing when you deal with China, because the data controller in China is called data processor, and as many of you know probably, data processor is under GDPR identified as another type of entity that normally acts on behalf of the data controller. So this can be quite confusing when you deal with those type of legislation. So, and similarly also India, they use different names. So data controller is named data fiduciary, data subject is named data principal. So what we want you to know here is that every time you deal with another framework, with another country, make sure to define or to establish which are, the set of laws or the terminology that you are going to use in your legal document, because this is key in order to avoid any type of confusion and any type of additional problem. Another thing that you normally will face when dealing with other countries is the fact that we are used to see privacy law as one unique law, but in most of the cases there are many other laws that can be laws you have to comply with. In the case of China, we are speaking about the personal information protection law because it is the one closer to data privacy, but there are at least other two laws that you need to consider that are related more to security, that are the cybersecurity law and the data security law. And this happens quite often also in other countries, and also as under the sectoral perspective. For example, healthcare is normally one of those sectors you should always be really conscious of which kind of laws you have to deal with. Now, comparing a bit the PIPL with the GDPR, in general, we would fit this law under the second box, so the one of GDPR similar structure. As you can see, Chinese law has principles as the one of the GDPR, is extraterritorial like the GDPR, has 6 legal bases that are more or less in line with the GDPR, and has individual rights, data subject rights as well. We can see here that there are already 2 elements that we have already seen in our previous slide. That is the fact that in China we don't have the legitimate interest as a legal basis, and we don't have data portability as one of the data subject rights. Another thing that you want to know about China is the sanction regime. The sanction regime in China can be compared to the one of the GDPR. They have cap fines and turnover-based fine. The interesting thing is this is one of the few cases where you can have penalties that are higher than the one of the GDPR, because the turnover-based fine can go up to 5%. Also, we have personal liability in China, so another thing to keep in mind. For what concerns data transfer, there is a requirement you need to be aware of, that is the data localization requirement. That means that when you exceed certain thresholds of personal information, you need to store the data within the Chinese border in servers in China. And we normally use experts and companies working, of course, from China in order to do that. Other few things, similarities and differences with China. We can see that there are requirements for privacy impact assessment that are more, let's say, specified than the one we have in GDPR. We have some indications for data transfer and requirement. In this regard, you need to know that you will have to deal with one specific authority in many cases, that is the Cyberspace Administration of China, also called CAC. The most interesting thing for data transfer is that also the CAC can provide a standard contract that is something very similar to what we have under the GDPR as standard contractual clauses, but we don't have binding corporate rules. So we cannot use this type of means of transfer in China. Another thing that is relevant for China is the fact that you may need a DPO, again, when you receive a data protection officer, when you exceed certain threshold again. But more interesting, you have to appoint a local representative. A local representative is similar to the EU representative we have under GDPR, but the point is that in this case, you have to appoint it in any case you deal with the law. So any overseas company dealing with PIPL needs to have a local representative in China. Last but not least, separate consent. In some cases, the Chinese law will require you to get a written consent separated from the others. This is normally to protect certain type of data like sensitive personal data. One of the most relevant elements of the Chinese law is also the security part of it. Under the security side, you can see here listed by our expert the 5 key articles and requirements to comply with this law. In general, if you are GDPR compliant, you are going to be more or less compliant also with this law. But normally the approach that the authority have for these kind of requirements can be a bit different from the one we are used to have under the EU. So our advice is always, again, to use expert that knows what the authority looks for when they ask for such requirements. So we had a little overview on a country framework that can be more or less considered similar to the one we have in the EU. Let's move now to India, where we face a different structure. First of all, why there is this difference? The reasons can be many, can be cultural, can be social, but probably according to our expert, one of the most relevant one is that the business in India is made mostly of small to medium enterprises. So what the government wanted to do in this case was create a framework that was easier to comply with for this kind of company. And what they did was creating a framework that is broader than the one we have in, under GDPR in terms of type of requirements. But the fact that it's broader, it also means that it is less prescriptive and more difficult to, let's say, interpret. And this is one of the key issues that was faced by our expert when dealing with it and reading and looking at the draft. The fact that there are uncertainties in its application by professionals not used to the legal system of India may arise. In terms of comparative with GDPR, we also have here data subject rights that are the data principal rights. What you want to know that also in this case, we do not have data portability and as one of those rights recognized. We may have a DPO requirement, but this is very specific. In general, you just have to appoint some point of contact for issues related to data protection. To comply with the DPO requirement, you need to fall within the definition of significant data fiduciary. That is an additional type of data controller, let's say, as we would call it in the EU, that is identified by the law. And basically, you are a significant data fiduciary when you handle big amount of data or you conduct type of processing that are particularly harmful. In that case, you have additional requirements, including the one of having a DPO to respect. On the security side, the Indian law cannot be compared to GDPR or PIPL. It's less prescriptive. There are just some indication at the legal level in the law, but there are no technical security requirements that have been provided so far. For what concerns data transfer, we have another relevant difference, consisting in the fact that we don't have specified any type of means of transfer. So you cannot use, for example, the standard contractual clauses or the binding corporate rules. They are not recognized by the law. What they will do is providing a white list of countries that is not yet published. So we have to see which are the countries that will fall within this white list. Other few things related to the differences between GDPR and the Indian Privacy and Data Protection Bill. First of all, on the side of the legal basis, we have seen that many countries all over the world count on consent. This is another of those countries, is heavily based on a consent regime. There is no specific indication of the possibility of using a legitimate interest, but they have something similar to it that is called deemed consent. It has various facets and forms. The most interesting to us for comparing it with the legitimate interest is the fact that the deemed consent can be recognized when there is a reasonable expectation of the individual to provide the data voluntarily. Our experts, however, says that it's better not to consider this as a legitimate interest because it's not specific enough, it's not detailed enough, and shouldn't be compared to that. So we used to consider that there is not such a legal basis under the Indian law as well. Another one that is particularly relevant is the data breach notification requirement in India. Why it's relevant for you to know about that? Because it's very complex for two main reasons. The first one is that the law does not distinguish when you have to notify the authorities and when you have to notify the individuals. So we are supposed technically to notify both of them whenever there is a breach. The second issue is that the definition of personal data breach is so broad that basically any type of incident should be notified, or most of them. So you can understand how onerous this requirement can become if it remains as it is at the moment. Two other things you may want to know: the notice, in order to inform the individuals, is simplified under the Indian law. So you have just to mention which are the types of data and the purposes of processing. And last but not least, the sanction regime has been enhanced, but we don't have a sanction regime that can be compared to the one of the GDPR. There are not, for example, turnover-based fines that is normally what scare companies the most. So which are the key takeaways we can extrapolate from this brief session together? First of all, GDPR compliance definitely helps to be compliant with other countries, but is not enough. So what can be the approach? Well, there are many and different, so everyone finds the best one according to the support of their legal expert. But in general, focusing on common problems, as the ones we have been looking at today together, is a good way to create scalable and defensive policies in order to be ready or flexible enough to change that parts that are different from one country to the other. Last but not least, similar compliance requirement can turn out to be false-free. Devil is in the detail. We have seen, like with PIPL, the difference between the sensitive personal data under the Chinese law and the European law. We have seen the case of India as well, where there is something like a legitimate interest, but at the very end is not a legitimate interest. So our advice is always to use and to speak with experts that really know the cultural and social elements behind each of those laws in order to make sure that you are preparing a compliant plan that is really fitting the requirement of the countries. This is the end of my presentation, so thank you very much for your attention. I hope you find it interesting, and I look forward to meet you over the course of this event. Thanks a lot.